It's almost sunset now, and I want to ask you a question. When I have a medical expert that I am cross-examining on the witness stand, who now fails to go ahead and answer my questions directly, what is the best strategy? What is one strategy that I can use to get the doctor to commit to answer my questions yes or no? Would you like to learn the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so let's say this is a medical malpractice case, and now the defense has put on their medical expert to argue that we do not have a valid basis for a case. Now, I get up to cross-examine this witness, and I ask him some basic questions. Doctor, would you agree it's important to keep accurate records? And he says, well, it all depends on how you define accurate, counselor. Really? You don't know what the word accurate means, doctor? Now, what if I were to instead say, doctor, would you agree it's important for a physician caring for a patient to keep thorough and detailed records? And now he knows what's coming. Well, he doesn't want to say that, yes, it's important to keep accurate and thorough and detailed records. Instead, what does he do? He says, again, counselor, it all depends on how you define thorough and detailed. It depends on what you want to include as important in the record. Okay, so there are some doctors who will argue with me, all because I was not precise in my question. And he may have a valid point. He may have a valid point because now those terms are subject to interpretation. What exactly is a detailed and thorough medical record? Okay, I'll give him that. So now let's turn it around. Let's say I ask him a question that calls for a yes or no answer. And now I say, doctor, are you able to tell me whether or not the patient who had this problem now followed your instructions? And now it's either yes or no. And now he goes into a long-winded answer. Why? Because I didn't give him specific instructions before I started questioning him. So what do I mean? I'll tell you what I mean. All right, at the very beginning of cross-examination, you'll find that some of the best trial lawyers in New York do the following thing. Doctor, I'm going to be asking you a series of questions that simply call for yes or no answer. Okay? And if I ask you a question and you're able to answer yes or no, do you promise to answer yes or no? And at that point, the doctor has to say yes. All right, so that's great. Sorry about that shake. All right, so now what happens then? What happens then is now I'm going to say, doctor, there may come a time where I ask you a question where you are unable to answer yes or no and simply don't know the answer. If that's the case, do you promise to simply say, I don't know the answer without giving me an explanation? And again, he's trying to appear reasonable, so he'll likely say yes, okay. And now, if I ask him another question, such as, doctor, would you agree that... No, let's try it this way. I may ask him another question. I say, doctor, there may come a time where I ask you a question and you're unable to answer my question yes or no. If that's the case, do you promise to answer that you cannot answer the question without giving me an answer why? And again, trying to appear reasonable, in all likelihood, the doctor's going to say, sure, no problem. So now, during cross-examination, I'm asking the doctor short, tight, leading questions because that's all I want to ask him. I don't want to give the doctor an opportunity to explain anything. So now, my questions are only going to call for yes or no answers. And if the doctor goes ahead and says, I'm sorry, I can't answer that question, let me explain, I'm now going to cut him off, say, doctor, you made me a promise just a few moments ago. You told me that if you couldn't answer my question yes or no, you would simply tell me that without giving me an explanation. Was there some part of that interaction that you and I had that you did not understand? Okay, so now he's already created problem number one. He's already violated the basic promise that he made to me. So now I'm going to ask him the same exact question. And if he can't answer the question yes or no, again, I expect him to say, I can't answer that yes or no, to which I'll say, doctor, no problem. I'll ask it a different way, or I'll ask a different question. But if the doctor continues to be a pain in the neck and turn around and say, I'm sorry, I have to answer the question by explaining, I'm going to turn it around again and say, doctor, let me bring you back to the first series of questions that you and I had, where I asked you a series of questions and you promised to answer yes or no. What did I do? I basically laid the ground rules. And now, if the doctor plays word games with me, you know what happens? I'm going to keep bringing him back to those simple promises that he made at the very beginning of my questioning. And I'm not trying to restrict the doctor. I only want him to answer my questions yes or no. Because as the attorney cross-examining a witness, I want to be able to tell the jury a story. and I either want this witness to agree or disagree with my statements. That's all I want him to do. And if he needs an opportunity to go ahead and explain, you know what? After I'm done questioning, the defense lawyer will have an opportunity to ask the doctor additional questions. Doctor, Mr. Oginski didn't let you finish that answer. Now I'm going to give you the opportunity to finish that answer. Can you go ahead and do that? So that's exactly what will happen if he felt that he was not allowed to answer that question. But this is how you control a medical expert, by asking and setting the ground rules at the very beginning of cross-examination. Why am I sharing this with you? I'm sharing this with you to give you a sense of what really goes on in these medical malpractice cases in New York. You know, I do recognize and I do understand you're likely watching this because you have questions or concerns about your own matter. Well, if your matter happened in New York and you're thinking about bringing a lawsuit, but have not done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day, everybody. Bye-bye.